Good afternoon, everybody. Happy Sunday. Hope everyone's having a great weekend so far. And we do have a very special guest today, as we all know. That's probably why most of you are here waiting for Brother Counsel's Brother Counsel. Well, I was also waiting for him, which is why we are running a drop late today. And actually, Solomon was in the middle of a softball tournament. And unfortunately, he made it to the championship game, which means that he had to hang around a little bit longer than he thought he may have expected. So he finished up championship. I think he actually left in the ninth inning in order to make it today for everybody to be here. Hopefully he got his last bat in or something. And that is why we're running a drop late today. But we are going to be talking a lot about the different Karen Reed testimony that we've seen so far. We haven't been with Solomon for a little bit of a while now, so we got definitely some catching up to do, which we are going to do today. I plan on showing him some of the more interesting clips that I thought were interesting with respect to the Karen Reed case the past week or two. So we're going to be doing some of that. And we'll be catching him up and seeing what he's got to say about these past few witnesses. Very important witnesses, obviously, in Karen Reed's defense case. So we had Burgess, obviously, and then we had Dr. Welchure, and then we had Kelly Dever, which I want to show him. And I also want to show him some of the Dr. Russell DNA issue that came up, the motion for a mistrial. The truth is that usually we have a little bit more time to talk before the show, so we're going to get a little bit more off the cuff than we usually get from Solomon. So I think you guys will like that. We haven't really been able to sit down and prepare the show today, so we're going to be getting really raw reactions from Solomon. So without any further ado, let's bring on Brother Counsel's Brother Counsel, national trial lawyer Solomon Radner. Welcome back to the show, and thanks for running over here in the middle of the ninth inning.
It's always an honor and a pleasure to be here. My apologies about my tardiness.
Well, what happened? Tell everybody what kind of happened with that last game in the championship. Where are they holding?
It was a charity tournament, and it was supposed to be over by around 1. And of course, we were way behind schedule, and we didn't end up getting to my team won the playoff game, and then we made it to the championship, and then of course the championship was just going slower than molasses, and in the bottom of the last inning, I was up. And that's when I called you. I called you from the on-deck circle, said I was going to be running a few minutes late. And then after I scored, I just basically ran right through the dugout, grabbed my stuff, told my team, I'm really sorry. I got to run. I took off, and I guess I'll find out later if we won or lost.
So when you left, were you winning?
We were losing by 4. When I crossed the plate, we were losing by 3 with 2 men on base.
Oh, boy. Okay.
So I guess we'll see. Yeah.
All right, I guess we're going to see. Well,
in honor of all the questionable police involved in this case, look what I got. A red Solo cup.
I think that's the perfect cup to be drinking out of when we're talking about the Karen Reed case. Solomon, before we jump into it, let me just ask you, because we have some hockey fans in the chat, and they've been talking about Edmonton or Florida. Who do you got in the Stanley Cup Finals?
I love McDavid and Draisaitl. I think McDavid is a generational talent. I've been cheering for him for a few years, and when the Red Wings didn't make it, I started going for them. Now, that said, last year I was going for Florida because I really liked Florida, but they picked up a player that I absolutely can't stand towards the end of the season, and that kind of made it easy for me for which team I was going to be pulling for. And of course, that player is the one who scored the double overtime goal for Florida, so it is what it is.
All right. Okay. Well, I also have Edmonton for the same reasons. I think McDavid deserves a Stanley Cup. Best player in the NHL by a long shot, and he deserves it.
He's abnormal. He's inhuman.
Yeah. Okay. So we got a lot to get to, and again, if you have questions, start putting them in the chat right now. Although we're not going to get to them right away, but definitely start putting them in, and I'll get to them when we can, when we have a break in the action. But as you know, we kind of left off because there was this Jewish holiday. As you know, you were out of town. I was a little bit caught up with it, so we weren't able to catch up on the past few weeks. And where you and I kind of left off was with Shannon Burgess. And you remember Shannon Burgess was the one with the issues of his bachelor's and he was kind of made to look like a little bit of a fool on the stand there. Yeah, so they had a good time with Shannon Burgess. And as we spoke about, Dr. Welchure, who is the Commonwealth's accident reconstructionist, who is supposed to be winning the day this time around for the Commonwealth, already going into his testimony, he's already kind of damaged goods by the fact that he works for Aperture, for a company that was displaying the false credentials of Shannon Burgess, and already the jury is going to be a little bit less receptacle of his less receptive of his testimony. So let me show you. Okay, we all been waiting for this. So I was waiting with bated breath to see what type of reconstruction did Dr. Welchure perform. So let me show you the type of reconstruction that Dr. Welchure engaged in and what was shown to the jury. So, and we can get your first reactions on his reconstruction. So let's pull it up right now. Take a look at the screen. This is it. There's a number of different ways that he was showing this on the video. If you can see, he's on the right. And what he did was he dressed up in the exact same clothing as John O'Keefe was wearing that night. So he's got that orange T-shirt. He's got the jeans. He's got the same exact sneakers. He's even wearing the hat. So he's completely dressed the part. And if you see, this is an aerial view, so it's looking down. And on the left is going to be the Lexus. On the right is him standing there. He's got some yellow paint already on his hand. And watch the reconstruction as it happens. Here we go.
What speed is the car traveling?
You can see it. About 2 miles an hour.
Well, that was the extent of his reconstruction, Solomon. And as you can see, he's got that blue paint. Let's see if they actually show it here.
That is the objection that we spoke about.
Oh, he's got that blue paint on the car, and it comes on his arm. He ran it into himself going 2 miles per hour. And that's supposed to show the jury that those injuries, remember you spoke about those injuries to John O'Keefe and what you think the jury's going to buy, whether that came from a car or from an animal. And there you go. That was him showing the jury proof that this car actually backed up into John O'Keefe, hit him in the arm, and left those abrasions on his arm. So that was the extent of his reconstruction. What do you think about it?
It was terrible. It was terrible. It didn't do anything. It didn't score any points. Here's the thing. I can only imagine that what they're going to do is they're going to have rebuttal experts, because I know that you've watched this past week a lot more than I have. I've kind of tuned in here and there, but I saw enough of the defense's reconstruction experts' testimony and the videos that they did, the crash dummies that they did, and the multiple speeds that they did. And if all they're going to produce is that one reconstruction, and then the defense is going to put on all of theirs, and the prosecutor went off on such a silly, this whole 26% thing. I'm sure we're going to get to it. It wasn't 26%. And he just kept saying it. He kept hitting it home. And again, I think these are things that you have to have enough self-awareness to know, am I scoring points with the jury, or am I simply pissing them off? And I got to tell you, I don't think he scored any points. Every time he said 26%, I think the jury just thought, no, you moron, it's not 26%. He already explained to you why it's not 26%. And then, I mean, look, I can only assume that the prosecutor is going to have rebuttal experts that are going to do a lot more reconstructions. If they don't, it's just another mistake by the prosecution. But if I can only imagine that once they saw these experts' reports, they got a whole bunch more reconstruction experts who are going to do rebuttal expert testimony.
Well, as far as we know,
the prosecutor goes again.
Well, as far as we know, the only rebuttal witness that he's going to be calling in terms of the reconstruction is Dr. Welchure himself, who after we're going to show you, that's going to be later on in the show, but we're going to show you the Dr. Wolf's reconstruction here. And then Dr. Welchure is going to be able to be called to rebut Dr. Wolf's reconstruction. So again, I remember when we looked at that picture in the beginning of the trial, and you said that it would be offensive to show that picture to the jury and tell them that it's from a car. And now that you saw Dr. Welcher's reconstruction, are you still of the same opinion that it's still offensive to the jury to ask them to conclude that it came from the car?
100%. There's no way that came from the car. Look, if it would have been a broken arm, some sort of thing that looks like a contusion, maybe. You take one look at the wounds, especially knowing that an ER doctor is going to get up and say this is clearly a dog bite. There's just no way. You have to change your theory of the case to that being a dog bite. You just have to. All right. And maybe there's a way that they could have done it. But if they're really going to try to convince a jury that those dog bite holes in his arm were made by a blunt force trauma of being hit by a car, that is offensive on its face. It's like trying to convince a jury that the earth is flat. You're not going to get there. You're just not.
And despite his reconstruction that he just showed there.
The reconstruction shows nothing. It doesn't show how holes get in his arm. All it shows is how paint gets on a sleeve. It doesn't show anything else. Now, if somehow he would have been able to do a reconstruction with a crash dummy of some sort with the same clothes, and look, I mean, you may have to run the test 5,000 times, but if one of them, the holes in the crash dummy's arm look like dog bites, then you could say, hey, look, we were able to reconstruct it, and look at this. The crash dummy suffered the same wounds that John O'Keefe suffered. But the way it is right now, no, that is not a contusion from being hit by a car. That is clearly puncture wounds that are inconsistent with being hit by a car.
Yeah,
There's just no way to get there.
And I was hoping to see some reconstruction with some dummies, which we're going to see later, because that's actually what Dr. Wolf did. And we're going to show you some of that. But I was really expecting, actually, for Dr. Welcher to get up there and show us this reconstruction with actual dummies and showing how these abrasions could have resulted from the car backing up and hitting John O'Keefe. All right, so let's move on to the next, I think, very important witness here. And this is a new witness for this case. Remember, this is the second trial. There's one trial already.
And some ringing. I'm going to take my headset off, and hopefully it's not going to make a difference. And if it does, please let me know, okay?
Okay. You let me know if you can hear me okay. Can you hear me?
Can you hear me okay?
I can hear you fine. Can you hear us?
Yeah, okay. Is it better or worse than it was a minute ago?
It's completely the same.
Okay, all right.
Okay, great. So moving on to the next witness, which I want to show you. This is Kelly Dever. Now, Kelly Dever is somewhat of a rookie cop. She's working right now at the Boston PD. Before that, she worked at Canton PD. And this is someone who was called to be a patrol officer, or she was supposed to be on patrol that morning, January 29th, going into the 28th, going into the 29th. And then when she got into the station, she was called by Sergeant Good to take over dispatch while he was going to respond to the scene. Sergeant Good has some ties to Brian Albert, some connections there. And again, Brian Albert is the homeowner, in case you forgot about that. And so she's kind of this rookie cop. She's on patrol. She probably should have been the one to respond, but they decided, you know what, you come in and do dispatch, and Sergeant Good was going to go out and respond to 34 Fairview. Now, she's got some very interesting testimony and some very interesting memories of what happened while she was at dispatch. And what's interesting here is, number one, before we show you the clip of the clip that I want to show you, is that she was never interviewed by the Canton Police Department or the Massachusetts State Police. The first time that she was interviewed was in August of 2023 by the feds. They interviewed her.
Did that come out yet? Has anybody accidentally said FBI yet?
No, they said law enforcement agency that's not associated with the Massachusetts State Police or the Canton Police. So
this judge is such a joke. Okay, all right.
Okay, well, all right, moving on. So she was very clearly not interested in being there. She was called by the defense, and in fact, she was asked, "Do you know why you're here?" And she said she has no idea why she's there at all. So, and then we hear the following testimony. So listen to this. This is what she told the feds about what she observed that afternoon, January 29th, when Karen Reed's Lexus was in the Sallyport. So take a listen.
Go ahead. Did you tell those law enforcement agents on August 9th, 2023, that you saw
Brian Higgins, and Chief Berkowitz go into the Sally Port together and alone with the SUV for a wildly long time.
That was my recollection at the time.
So you did say that.
At the time, that is what I recollected.
Okay.
So did you hear that recollection?
Don't
So
tell me
this
she
is
changed her mind later.
Yeah. So what happened here is that what she did was she said, well, initially she told that to the federal investigators. And then she, I guess, got some more reports from the defense or from whatever she got these reports from, where she decided that actually she was not at the station when that could have happened, because we know that Karen Reed's Lexus got to the Sally Port around 5:35 p.m. And she claims that she left the dispatch, I guess, at 3:45, 4 o'clock p.m. And therefore that memory that she had must have been a false memory. Now, you spoke about false memories in our last show. Remember when we were talking about, you gave that scenario where a bunch of people were in a room and somebody came in and grabbed a purse, and, kind of other people implanted false memories into the other people there. Here you have a police officer talking to the feds saying that's what she recollects, a very specific memory, a very specific recollection of two people going into the Sally Port for a wildly long time. And now she's saying, well, I must have been mistaken about that memory. What do you think the jury is thinking about that?
So, okay. Well, first of all, juries don't know how false memories can be. Okay. A lot of lawyers don't know how false memories can be. And identifications also. There's a lot of things that come across as very truthful that are really very, very untruthful and just not intentionally. Like, for example, if somebody gets robbed at gunpoint by a stranger and then try to identify that person later, they'll be wrong up to 75% of the time. If it's somebody that they saw once under high pressure for a split second or two and then left, that misidentification will happen up to 75% of the time. So it's kind of similar with false memories. So number one, the jury's not going to know just how false memories are. Number two, that is absolutely not applicable here, because it's not a situation. Okay, the way false memories work is you're there, you see something, and they kind of twist your memory. You see a jacket, and they implant the false memory that it was a blue jacket, okay, or a red jacket. Or you see a person there, and they input this memory into you that the person had facial hair or glasses. Okay, to completely create a fake memory like you see in sci-fi movies, that doesn't happen in real life. So if she told a law enforcement agency that she saw them go into the Sally Port for a wildly lengthy period of time?
Wildly long time.
Okay, and then now in front of the jury, she's saying that must have been a false memory. At that point, I don't see how you're not allowed to bring up on cross-examination, or maybe it would be redirect examination on for impeachment purposes. You were talking to them under penalty of perjury, weren't you? And at that point, you have to bring up the fact that they were the FBI, because it goes to show the lengths to which a law enforcement officer is not going to lie to them and be 100% truthful. So at that point, I don't see how this judge can, again, if she's not horrifically biased, which I think she is, but if she would actually be fair in this case, I don't see how that wouldn't be fair game under cross-examination. Officer, you were speaking to the FBI, weren't you? And you're aware that when you lie to the FBI, that's not just a potential state felony, that's a potential federal felony. Are you aware of that? You're aware that people go to prison for that? That's obstruction of justice if you lie to the FBI. And now you're telling us that that's a completely made-up memory? It just, I don't think it's going to come across as truthful at all. And again, there's so much reasonable doubt in this case already. It's almost laughable.
Well, she did allow Jackson to ask her about the fact that she understood that if she lies to this agency without saying the FBI, that it is a crime in itself. She did allow him to bring that out on cross-examination, but still she's not allowing this part about it being from the federal investigators or anything that has to do with the FBI or DOJ or anything like that.
I think federal changes everything. I think that everybody from unsophisticated people to the most sophisticated jurists and lawyers and judges understand that once you throw the word federal in there or FBI in there, it's a much more serious situation.
Mhm.
That's
Okay.
it. I don't see how it doesn't come in. But again, she's made so many ridiculous, outrageous rulings in this case. It sadly doesn't surprise me. Just another one to add on to the scale.
Yeah, well, okay. So then moving on from that, she also testified that after that interview with the federal investigators, she was called into the commissioner of the Boston Police Department's office between, I guess, when it's between when they spoke to her first and when she gave that statement in August of 2023. Now, in the first trial, they didn't call her, and they had a conversation between David Yannetti and Alan Jackson and some of them and Elizabeth Little, people on the defense side. They had a conversation with Kelly Dever about her recollection, and she told them that she was actually called into the commissioner's office and was told, number one, that we completely are behind you. We support you. And we'll see what she says also, they said. Okay, so just take a look. Listen to this about that interaction.
This came out, one second. This came out during who's questioning?
This is all still Alan Jackson's questioning. All right, so take a listen.
Between the time that you were interviewed on August 9th, 2023, and when we spoke sometime in maybe it was April or so of last year, does that sound about right?
Yes.
Did you have any conversation with any other party about your potential involvement in this case?
No.
Did you have a conversation with anybody in the commissioner's office at Boston Police Department?
Not about anything malicious.
I didn't use the word malicious. Why do you say malicious?
I had a conversation.
Did you hear that part?
Yeah. Yeah. Sometimes witnesses try to get ahead of the ball. They get ahead of the 8 ball, and all they do is ruin themselves. There was another witness who did this also. Oh, I remember. Jen, right?
Yeah, Jennifer McCabe. Exactly.
Yeah. She said something, nothing nefarious.
Exactly.
He was like, nefarious? It's like when you try to get ahead of the 8 ball, all you do is end up hurting yourself.
Okay, continue listening.
But it was my department saying, regardless of what I need to say on the stand, they support me.
You were asked to go to the commissioner's.
So then he continues saying that. So first she says, yeah, they're just telling me that we completely support you. Right? Okay, so we support you. And then he said, yeah, but you told us something else also. You told us that the commissioner said, do the right thing, that you should do the right thing. And for that, she said, well, I don't recall specifically if that's what he said or not.
Was that documented anywhere?
No.
Was it testified to anywhere?
Nope.
How does Alan Jackson know that that was said?
Because he was part of the conversation when she told him that.
Who was? Alan Jackson was?
Yeah, they contacted her before the first trial, seeing if they're going to call her as a witness. And when they were talking to her, they're asking her, well, were you called in by anybody, I guess? And she said, yeah, the commissioner. And he said, what did the commissioner tell you? And he said, well, the commissioner told us that, it told me, it was just them two, nobody else there, just told me that, we completely support you, we're behind you, and, do the right thing. So that's what he was trying to bring out from her.
Did
and
you record that conversation? Please say yes.
Did
she deny that she said that to him?
She said she doesn't recall if that's exactly the words that she said. What does that sound like?
It sounds like she's not being truthful. It sounds like she's, again, not being truthful now. And it also sounds like the police were basically telling her what to do and say. That's what it sounds like.
So continue listening a little bit more to the. I
can tell you right now, her demeanor is not good. This is not a witness who presents well. There were other witnesses, and here's the thing: there have been so many witnesses in this case, some of who have been completely honest, and some of whom have not been. And you could just compare the body language. You could tell how aggressive she's being. She has an aggressive posture. The way she's answering questions is aggressively. I don't think she's making a good witness. I really don't.
Yeah, I mean, you should see it from the beginning. I mean, from the beginning to the end. I'm not going to play the entire of this direct examination, but yeah, I mean, right away he's asking her questions. She's going off on tangents. And he's like, I'm not talking. Let's just concentrate on my question, like how you got to refocus the witness. But anyway, listen a little bit more to what he's
Correct.
bringing out here.
Yes.
How long had you been on the Boston Police Department at the time that you were invited to go up to Commissioner Michael Cox's office?
It had to have been before the first trial. So, and I know it was when the agency released information to outside people.
That's not my question.
Okay, so I don't recall.
Okay. You don't recall how long you had been on the force, generally, at the time that you were called up to the Commissioner's office, on the Boston Police Department?
No.
Was it 5 years, 2 years, 2 months? Give me a ballpark.
So I've been on the department for 2 years and 2 months. I would say somewhere in the range of a year.
Okay. Did you find it unusual would you call yourself a rookie back then?
Yes.
Did you find it unusual that a rookie police officer would be called up to the Commissioner's office personally to discuss a matter?
It was a reflection of how good of a leader he is. It was not anything that I found unusual, given the fact he is someone who wanted to show support for his officer.
Right. So she's been on force for about a year, gets a call from the commissioner. We're completely behind you. Then Jackson asks her, oh, so is that what he does with all the rookies? Like anytime they're going to go testify, does he say we completely support you behind this? Or is it just, specifically to this case where he wants to tell you, by the way, do the right thing?
Yeah. I mean, she's clearly being played with, and the thing is, she's being manipulated, and she thinks this is just part of the game. This is part of the blue wall of silence. I don't know if that's come up yet or how many times that's come up yet, but this is the definition of the blue wall of silence. If and some cops do and some cops don't, and I always respect and appreciate when there's a police officer on the witness stand or being deposed and they're willing to be truthful and say, yes, this was wrong. And I've had that happen. It's exceptionally rare. I would really want to see it happen more often than it does. But this is what happens when a police officer is testifying. They virtually always will protect other police officers. The reason I'll tell you right now, when the FBI came in and they were interviewing her, that's probably why she was being straight with them, because at that point it's she and them, law enforcement, taking on these other guys, and then later, it was like, no, you're not supposed to do that. You're supposed to be behind your guys. So, and I'll tell you one more thing. I know that a lot of people don't really want to go there, but I almost understand why police officers do this. It bothers me, and I find it troublesome, and I wish they wouldn't. But when cops are willing to snitch on other cops, they get labeled, they get attacked, they don't get promotions. There were some police officers in Baltimore who came forward with some very, very troubling information about some other Baltimore police officers, and the guy found a dead rat in his windshield wiper one morning. And that's the kind of stuff that happens. And then the sad reality is, tomorrow or the next day or the next week, those 5 same police officers may be clearing a drug house. And what do you think is going to happen then? Oh, whoops, it was friendly fire. Or, oh, whoops, I didn't see that guy shooting at him quick enough. These are people that that these officers ultimately have to put their lives in their hands. So I almost understand and see why they're willing to lie for each other. They have to protect each other at all costs. They protect each other's lives. But at the same time, that doesn't excuse it. It really doesn't.
Yeah. And another thing that came out from her testimony was that she said that during that conversation where she basically told the defense that she's not going to stick with her statement that she gave to the feds, that she saw Higgins and Chief Berkowitz. And by the way, that's why there's also a lot of questions about, did they swab Chief Berkowitz and Higgins when it has to do with the car? There's a lot of questions about that. Now we're seeing why that's coming in, because if they were there in the Sally Port playing around with the car, well, then maybe their DNA would have been found if they would have been swabbed. Now, another thing that came out was the following, that during that conversation, she said, and this is what she said on I guess you can call it cross, because this was the defense called her as a witness, was that she was threatened by the defense. This is what she said. She was threatened with being charged for perjury if she decides to change her statement from what she gave to the feds.
Who threatened to charge her with perjury? The FBI?
No. What she said was that the defense in that phone call, they were very upset when she said that she's not going to stick with that testimony because it was just a faulty memory. And they said something about, well, we're going to charge you with perjury. So she said that they threatened her
You
to
say
charge
that
her.
Alan Jackson said that?
That's what she said.
What a joke. This woman's a joke. There's nobody in the world who's going to believe that. Defense attorneys don't charge crimes. And now, of course, this comes down to whether or not this ridiculous judge is going to allow them to bring that out. Did she?
So, well, she did actually. So Alan Jackson.
Then good. Then she looks like a liar. Because for a cop to get up and say, I thought the defense attorney was going to charge me with perjury, you lose all credibility. There are certain things that when you say them, they're so extreme and so ridiculous that you lose all credibility. It's a joke.
And that's exactly what Alan Jackson did on recross or redirect, whatever you want to call it. That he said, you're a police officer, right? So can defense attorneys charge anyone with perjury?
So what did she say to that?
Yes. Well, she's like, well, they can recommend it, and then yeah,
No,
the
they
DA
can't. No, they can't.
something like that.
Police
So,
recommend, prosecutors charge.
yeah. So whatever. That was her explanation there why she thought that they're trying to threaten her with perjury charges coming down because they're going to contact the DA's office and make them charge her with perjury. Anyway, so that was another part that came out from her testimony. Okay, so moving on. Let's move on from Kelly Dever because, yeah, I think we all saw the demeanor and some of the questions and the faulty memories, and the jury can already be thinking, is this, again, like that thick blue wall? But then we moved on to Dr. Russell. Okay, now Dr. Russell took a long time, but essentially what her testimony came down to was the following. She's an ER doctor. She's a forensic pathologist for both of them for about 30 years. She's done like 1,000 autopsies or something, and she's probably seen also probably like 1,000 dog bites in the ER. And she testified that using pattern recognition analysis, she's able to tell that these injuries to John O'Keefe's arm are the result of a dog attack. Now, she wasn't allowed to say attack. That kept getting objected to, and the objection was sustained. Dog bite, right? So she had to say dog bite. So but that was her testimony after about a day and a half of testimony. Does the
prosecutor have a rebuttal expert who's going to be an actual expert in this? I know they got some ridiculous expert. They
have a dog behavior expert.
A dog behavioral expert, yeah.
Yeah, not an ER doctor.
An ER doctor on rebuttal?
Right. No, they don't have an ER doctor on rebuttal. So they may call this guy Crosby, who's a dog behavior expert, who's going to say that these are not consistent with a dog attack. It seems like they still have that option. But anyway, this is what interesting that came up. And this is where a lot of people were thinking about you, because we spoke about how many times you moved for a mistrial in the middle of your trials, and I know I've been there.
I was just thinking that I didn't want to bother. I don't want to bore your audience with that again. But yeah.
Oh yeah, no. And every time you do that, and I'm with you, it's hard for me not to chuckle. But yeah, I mean, like, you move for mistrials all the time, and when this happened, so let me just set the stage before we see some of the argument here, and that was that Dr. Russell testified, that these are dog bites. Now, if it's a dog bite, that means that the dog bit through. And she also testified that the holes in John O'Keefe's sweater or sweatshirt or hoodie, whatever you want to call it, that was also associated or consistent with being a dog biting through those that sweatshirt. And what happened in the first trial, and the reason why I say first trial and stress that, is that in the first trial, the Commonwealth called a DNA expert who did some tests on the sweatshirt, and there was no dog DNA on the sweatshirt.
This was after Proctor had it for like 3 weeks, right?
This is after what?
Proctor had the sweatshirt for like 3 weeks.
Oh yeah, of course.
Okay.
So
that testing is meaningless.
Right, but that's what happened in the first. At least that testimony was given at the first trial. Now, in this trial, the second trial, they did not call that witness. The Commonwealth rested without calling a DNA expert, saying that there's no dog DNA that was located on the sweatshirt. Okay, but on cross-examination, Hank Brennan asked one of a lot of his lines of cross-examination was what she was not aware of, and that the fact that she's not an accident reconstructionist. That was mostly his cross-examination was, you're an ER doctor, not an accident reconstructionist. So and she didn't go to the scene and do measurements, like things like that. So he brought out the fact that was she aware, or she was not aware, she was aware that there was no DNA located of no DNA of a dog that was found to be on the sweatshirt. And that is what caused Robert Alessi to make the following motion. So listen to the motion.
Wait, hang on. Before we get to the motion, what happened? I want to hear more about this actual testimony. So Hank Brennan asked her, "Are you aware that there was no dog DNA found on the sweatshirt?" And what was her? There was an objection, and then this happened, or was there an answer? I'd really like to hear what the follow-up to that was. That's really interesting.
Right. So I don't remember exactly the if there was an objection before, or if she gave the testimony before or after. I don't remember exactly. But once that question came up, she must have said that she was aware of that. That's what I'm assuming. And again, I just don't know for sure. But this is what resulted after that line of questioning.
Okay.
Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function, simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made, that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened? This is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is in.
Okay, so you get the point. The point was here that the prosecution did not bring up DNA at all with any of their witnesses, and therefore you cannot cross-examine Dr. Russell on the lack of DNA, because there's no evidence that there's a lack of DNA.
Right.
And therefore they move for a mistrial. Now, before I tell you what Judge Cannoni ruled about it, why don't you tell me your thoughts about the merit of that motion for a mistrial?
I'm sure she didn't grant it. There's no way that she did, because she's incapable of being fair. The question is, should it have been granted? I don't think it should have. I think that this is very, very improper. I think it was done intentionally. And unless he's right, that the prosecutor is not going to be able to bring a rebuttal expert to say that there was no dog DNA on the sweatshirt, because the only thing that they get to do is rebut arguments and positions that were articulated by the defense. If the defense were to put up an expert who would say there is dog DNA, then the prosecutor would be allowed to put up an expert on rebuttal to say there is no dog DNA. But if the defense does not address it, the prosecutor doesn't get to bring it up on rebuttal. Just so we're all very clear. I know you and I are lawyers, and maybe some people watching are lawyers, but I think most people watching are not. Rebuttal is not an opportunity to just reopen and relitigate whatever you want. You are only allowed to address specific points that were made by the defense. If the defense made points A, B, and C, you are only allowed to rebut points A, B, and C. You're not allowed to rebut points X, Y, and Z. And so, no, there's no way that he's going to be allowed to call a rebuttal expert, unless, of course, Judge Cannoni says that they can, which would be another horribly improper and ridiculous ruling that she's made. Add it to the list. I'd really be surprised if she allows that, because it's so basic, it's so elementary. And even this judge, I think, will get that right. As far as whether it should be granted, I think that a curative instruction should be given, and it should be a very strong one. And it should be a strong one, letting the jury know that what the prosecutor just did was improper. And I've had this happen to me in trials. It goes both ways sometimes, where a judge will say, hey, whoa, time out. That was wrong. I'm going to have to admonish you in front of the jury. I actually had a judge do that to me once. Probably 6-7 years ago. I was trying a case. There was no way I was going to win this case. And there was questionable evidence whether I'd be able to get it in or not. I tried to get it in. And then the judge called the timeout. We went sidebar, and he said to me, I'm going to have to admonish you about that in front of the jury. And I argued that he shouldn't, but he did. And he got up and he told the jury, Mr. Radner just suggested that this evidence, blah, 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 whatever. That's what I think should happen here. I think it should be very strong. I think the judge should make it very clear to the jury that it was improper and it was misleading and it was untrue, and they're not going to hear any testimony or any evidence at all about any dog DNA. I don't think it's grounds for a mistrial. It's just not. It's not strong enough. It's not strong enough.
So let me just play again a little bit devil's advocate, because that's what I like to do here. What about the fact that if she testified that a dog's tooth went into that sweater or that sweatshirt, is that enough of a foundation for the prosecution to say, okay, we get to rebut that fact by showing evidence that there was no dog DNA, because her testimony wasn't a dog tooth went in there?
No, and I'll tell you why. What they could do is they could ask her, was there any dog DNA? They could ask it as a yes or no question. They can't suggest that there was. It's very improper to do that. And Hank Brennan knows that. He knows what he did was wrong. He probably knows he can get away with it because this judge is ridiculous. But no, absolutely not.
Okay, and what about the fact that there were previous proceedings in which she was under oath, Dr. Russell, before this trial, and they spoke about the lack of dog DNA. So what about the fact that it was brought up with her before, prior to the trial, and therefore that would open up this line of cross-examination to be explored?
No, she's not opining on that. That's not part of her opinions that are being offered by the defense. And the fact that it was brought out in a previous cross-examination where other evidence was brought in on that topic, it may have been admissible there, but it's definitely not admissible in this situation. There's just no way. There's no way you can do that. It's like if there's, there's a lot of different examples that we can give of this, but no, you can't say, are you aware that this, that, and the other thing? And it's like, you can't say that unless there's a basis to say that. And if you know there's not going to be any evidence coming into that effect, you can't bring something like that up.
Mm-hmm. Okay. All right. So let's move on to Dr. Wolf. So now Dr. Wolf took the stand, and he was very impressive, obviously. And he did a whole bunch of tests. I'm not going to play for you all the tests. You can all watch my recaps. I played all the tests there, just the clips of the test. But I think this is the most interesting test, which is probably the most similar to the Commonwealth's theory. Now, remember, the Commonwealth's theory, again, this time around, is that they don't really know exactly what speed Karen Reed's Lexus was going. In the first trial, they did know. This trial, they don't really know. So they're kind of leaving that open for the jury to figure out at what point or how fast Karen Reed was going when she hit John O'Keefe. So what they did was, what Dr. Wolf did, is that he performed a reconstruction with a dummy, and he did it at a number of different speeds, but this is the speed where he did it at 24 miles per hour. He lined up the dummy's arm with the exact area of where Dr. Welchure showed with his paint test where his arm would be. So according to his theory, that's where the arm got hit. And he lined it up there. He had the car go back 24 miles per hour. And this is what the test looked like. So let me pull it up for you here. And this is the ARCA's test. You see, that's in slow motion. So that you should just know it's just the car is going 24 miles per hour.
Backwards?
But it isn't in backwards. Yeah, you see the
How
car
is it
going
24 miles an hour backwards?
How is it?
Is somebody driving it or is it being propelled somehow?
Yeah, no, there's someone's driving it. Okay, so take a look at this is how ARCA reconstructed this. Not with any blue paint, not with, and by the way, he's wearing the same exact sweatshirt as John O'Keefe was wearing. And same jeans and same shoes and everything. So here, it's actually reconstruction where he's wearing the same clothing and the car is actually not going 2 miles per hour. It's going 24 miles per hour, which is the fastest the car was going at this last tech stream event, which again, we heard that it could have been going faster afterwards, but this is what it was like going 24 miles per hour. Take a look.
Can I just ask you a more basic elementary question?
Sure.
What year was this Lexus, and can it even go 24 miles an hour backwards?
Yes. I mean, this is the exact same Lexus, exact exemplar.
Okay.
Everything was the same. And this is what his reconstruction shows. So take a look.
Okay.
So that's what it looks like when you actually do a real reconstruction. And I will tell you that there's a lot of people now on the anti-Karen Reed side, which, as you saw those the tail lights smashing, you saw pieces flying around, and so like, hey, that actually looks pretty similar. Now, what Dr. Wolf did show afterwards is that he showed the tail light what it looked like after this interaction with the dummy. And then he also showed the taillight of what Karen Reed's Lexus looked like. And Karen Reed's Lexus, her taillight looked a lot worse. And also some of the internal components of Karen Reed's Lexus was also much more severely damaged than the internal components of this taillight on the exemplar which they performed this test. Additionally, this test showed that there was no holes that was created by those taillight pieces, even though they were flying off. There's no holes that were created in the sweatshirt, which is the same exact sweatshirt that John O'Keefe was wearing. Not even one hole in that sweatshirt. So I think if you'd have to ask me, does this help the prosecution or if it helps the defense? I think it absolutely helps the defense, showing that number one, the internal components weren't busted. Number two, there's no holes in the sweatshirt. And number three, I'm sure we're going to hear from Dr. Renschler, who is another biomechanical engineer, and he talks about the injuries. He's going to say, well, if we are to assume that this happened, most likely he's going to talk about how there must have been a lot more contusions and fractures,
broken arms, hematomas,
and things like that. So we haven't even heard about that, but the anti-Karen Reed people are celebrating this, I think, right now, saying that, hey, that just proved the case. What do you think?
Okay. Are there dog bite marks in the sweatshirt or in the dummy? Was there any experiment done where there were dog bite marks? Because if not, you get halfway there. Okay, fine. The tail light shattered. Good for you. But unless you can actually prove that that a similar injury would happen to the arm, you're only halfway there. And then obviously that's not what happened here. You got to prove 1, 2, 3, and 4. If you prove 1 and 2, great. You didn't prove 3 and 4. In fact, you disproved 3 and 4 in this case, because it clearly these injuries clearly were not done by being hit by a taillight. But also the internal components of the taillight, that's a real problem for the prosecutor, because I'm guessing that there's going to be testimony that will say, well, those internal components could be damaged by, say, a baseball bat in a Sally port.
Right. And something else is that this is also very interesting that came out all the way at the end. I mean, this is like what the jury was like their last little bit of testimony that they heard from Dr. Wolf, almost like the last, which is a great point by Alan Jackson. And that was that, because one of the things that Hank Brennan showed is that, look at all those pieces of taillight flying around, and some of them are even touching his sweatshirt. So, kind of laying the foundation that, well, it's possible that, in a different scenario, it actually did pierce the sweatshirt. But something that Alan Jackson brought out with Dr. Wolf was the fact that, let me ask you a question, Dr. Wolf. How fast was the taillight and the arm going when it made contact with the Lexus? And he said, well, they would both be traveling the same exact speed, right? They're both sped up to the speed of the Lexus. So he said, okay, well then how is there going to be enough force and speed of the taillight to then puncture the sweatshirt? And the answer there was, well, it would somehow the taillights would have to go faster than his arm, because it's got to catch up to the arm, pierce it, and also leave those abrasions on the arm, which he said, quite frankly, is impossible. So that was kind of like the last part of his testimony that was left in the jury's mind. Now, something else.
Let me tell you something. Unless they're going to have an expert who will get up, a reconstruction expert on rebuttal, who will be able to explain to the jury how puncture wounds happen from a taillight, not just by cross-examining an expert, but by actually putting forth an expert who will be able to say, here's an experiment that I ran, here's a reconstruction that I ran, here's exactly how it can happen. If the prosecutor doesn't put that on, they are done. This case is over, because you can't get over that. And again, you never know what a jury's going to do. Frankly, between you and me, and I know you know this already, the jury already knows what they're going to do. Okay? I'd be shocked at this point if there's any juror still on the fence. I just would be.
Yeah, well, in the first trial, there was reported to be a hung jury, at least at the second count. But anyway, let me point out one other thing that I want to get your opinion on. And this is something that we've spoken about, and I know trial lawyers talk about this, and when you're preparing to put your own witnesses on the stand, we always talking about bringing out the weaknesses in your case with your witness. Right. And we've been critical about, Hank Brennan failing to do that. And then when Alan Jackson had Dr. Wolf on the stand, and one of the things that we all know about at this point is that there were some communications between Alan Jackson and Dr. Wolf. There were some text messages through Signal, and they were deleted. And we knew, and again, I know that if it's you or me, we're going to do our best to bring that out in our own direct of our witness.
Did he not bring that out?
So,
that out.
Right. So what I'm convinced of now, I think it's more of a hunch, more than a hunch at this point, is that I sensed, and maybe some people didn't catch this because it was objected to and immediately had to move on, but this is where I saw Alan Jackson going with this line of questioning. And then he kind of there was an objection and he had to move on, which makes me believe that Judge Cannoni did not allow him to explore this. So take a look, listen to this, and you tell me whether you think this is what's going on also.
At some point, subsequent to that initial discussion in February of 2025, did we have another discussion about the potential of retaining you?
Yes.
Tell me about that. When was that?
From what I recall, it was sometime in March, and we were trying to figure out.
Sustained. Next question, please.
Did I ask you if you were available to be retained by the defense?
Sustained.
May we approach?
Okay.
This might just be hearsay.
So they approach.
Yeah.
And then he's talking about the communications that he's had with Dr. Wolf for retaining him. And I assumed that the next line was going to be about the text messages. And he didn't talk about it. And then he just moved on with his cross-examination. So something tells me that he wanted to, and that was part of the problems of what Hank Brennan, maybe in Judge Cannoni's courtroom, if it's direct examination, you're not allowed to bring out these bad things about your own witness. What would you think about that?
It's ludicrous. I can't imagine that's the ruling. I would really sincerely hope that that's not the ruling. I mean, based on the way the question was asked, it was hearsay. Did I ask you? Did I tell you? You can't do that. You can say, have you and I communicated? In what way did we communicate? Where are those communications? If she didn't allow that line of questioning, that would just be ridiculous.
Mhm.
That would be completely ridiculous. If there's a cross-examination topic that you know your expert is going to be subject to, you are absolutely allowed to bring it up first. There's no question about it. There's absolutely no question about that.
Right. And I would think that Alan Jackson knows this, and I would think that he would want to bring it out, and he didn't, which is just really has me scratch my head. Is this something that's we're just seeing, you know, that area not being explored by Hank Brennan and now the same mistake by Alan Jackson? Or is this actually based on some sort of ruling that Judge Cannone does not allow you to bring that negative stuff out about your witness?
Well, there's two possibilities here. Possibility one is Alan Jackson didn't want to bring it out, which would shock me because it would be such a terrible strategic mistake, in my opinion, not to bring out all those deleted texts if you know the prosecution is going to talk about it. Or Judge Cannone just made another asinine ruling. And without knowing which one of those two things happened, just based on the number of asinine rulings that Judge Cannone has made, compared to the number of strategic mistakes that I think Alan Jackson has made, I think the asinine ruling numbers far outnumber the mistakes made by Alan Jackson. And if I had to just guess which one is the reason here that he wasn't able to ask questions about the text messages that were deleted, I would have to assume that it was another asinine ruling by this judge. But I don't know for sure. There's no way of knowing.
Yeah, I guess we'll find out maybe after the trial. But that's just something I'd really, really like to know myself, because it's something that we've been critical of, you and I, and I think maybe other lawyers who are watching this. You know, anyone who's been in trial before, has some trial experience, knows that you got to get in front of this stuff. And we keep seeing it play out. So maybe it is subject to some sort of ruling. That's something I'd like to ask the attorneys about after, when the gag rule is the gag order is lifted. All right, well, let's get to some questions.
By the way, I know that there's a lot of talk about encrypted messages and encrypted apps and all that. It's such a dirty way to present it, because virtually every messaging app is encrypted. Okay, iMessage, iPhone to iPhone, iMessages are encrypted. WhatsApp messages are end-to-end encrypted. Signal messages, as we know, are end-to-end encrypted. So to say something like, you were using an encrypted app, how dare you? It's like, yeah, everything's encrypted. So yeah. I don't know where that went, and I don't know how that all came out, but I just remember there being a whole bunch of stuff about encrypted, and I'm sure that Hank Brennan spent a long time cross-examining this expert on the deleted text messages.
Yeah, he did. And he talked about the signal. He talked about deleting the text messages. You're exactly right. All right, let's get on to some questions, Solomon. First of all, thank you, Joseph Gaglio, for becoming a new member. Let's move on to this question. Kat, I'm curious if the judge will rule on the missing witness motion before the defense rests their case. If she rules against the defense, could the defense change course and call Proctor and Higgins? So I'm not entirely familiar with this motion. I haven't been able to see the motion. I'm not exactly sure what it's about. Missing witnesses, I'm not exactly sure what you're talking about. But that may be my own ignorance, and I apologize. But I always was wondering something. I know you and I spoke about the fact that if we were the defense, I think we'd both call Proctor and Higgins. And it looks like at this point, now I will say they got the text messages in. That was another part of their case. They called one of Proctor's friends. They got some of the nasty text messages in. Would you still feel that you should call Proctor by the defense, and then you can make the case to the jury that, hey, the Commonwealth didn't call Proctor because they're trying to hide him, but we want you to know the truth, so we called him? Or is it better at this point, if you get the text messages in, to just say, hey, the Commonwealth is so incompetent or not confident with their case that they're not even calling the lead investigator in this case?
So that's interesting. I was saying the entire time that the defense has to call Proctor. You just got to call him. I don't think you got to call him anymore. In fact, I think that based on how strong the defense is, there would be very good reason not to call Proctor. And here's the problem with calling Proctor as the defense. If you need to obliterate him for your case, then that's great. Call him if you need to. If you don't feel that you need to, then there's very good reason not to call him, for this very simple reason. The prosecution then gets to cross-examine Proctor, and they get to ask leading questions. And I'm sure by now everybody who's watching this will know that on cross-examination, you're allowed to ask leading questions. And on direct, you're usually not allowed to. Now, if you call a hostile witness, like if, let's say, I call a defendant, if I'm the plaintiff and I call a defendant in my case in chief, then I'm allowed to ask leading questions because he's clearly a hostile witness. I just had this recently in a trial where I called the defendant and I was asking leading questions, and the judge, the defense attorney objected and said, "Objection, Your Honor, that's leading." And I kind of looked up at the judge. I was kind of surprised because this attorney I know should know better. And the judge in front of the jury looked at her and said, "You really think that Mr. Radner and your client prepared this testimony?" Because that's the concern. The concern is that you're going to prepare the testimony and say, "I'm going to ask you a bunch of yes or no's," and you just answer them accordingly. But the problem is that if the prosecution gets to cross-examine Proctor, they get to ask a whole bunch of yes or no questions, and they get to get in exactly what they want to get, how they want to get it in. So again, if the defense was in a position where they had to call Proctor for their case, then they kind of have to risk it. They got to do it. But their defense is so strong, and they have completely destroyed the prosecutor's case. And there's so much reasonable doubt in this case that, I mean, I've already told you, I don't think this case should even go to a jury at this point. But I don't see how in the world you're going to get 12 intelligent, impartial people to say guilty on any of the charges. So at this point, I think there's a very good reason not to call Proctor.
And I guess you would say the same thing for Brian Higgins.
I would say the same thing for Brian Higgins. Yeah. Because again, here's another thing that your audience has to understand. If, let's say, I call Brian Higgins or Michael Proctor and I ask 10 questions on 10 very specific topics, the defense or the prosecutor gets to cross-examine him on any topic relevant to the case, even if I didn't bring it up. There's no scope of cross-examination. On recross or redirect there is. Then there's a scope of what was brought up in the last examination. But if a witness is called at a case in chief, on cross-examination, you're allowed to bring up any relevant topic. So they're allowed to have him on the stand for 2 days, 3 days, and try to rehabilitate him with a series of yes or no questions. They could take him through, all kinds of things to make him look like a good guy. And I think it'd be much harder without being able to lead. So that's probably why the prosecutor didn't call him, because they know that if they call him, Hank Brennan, to his credit, is aware of how horrible of a witness these two people will be. And if he calls them, he knows that Alan Jackson is just going to go to town on them. So he's trying to keep them off the stand in a way, or at least that if they get to the stand, it'll be in a way that he can ask them leading questions. This is good strategy by both of them.
All right. Nightclub says, "I've been waiting all day to watch your brother." And that's you
talking to me or Martin?
You, because you're the brother. I'm just brother Counsel.
Okay.
Nightclubs says, "Love Solomon. He's better out number 2." Referring to
Better as the guy representing Turtle Boy?
Yeah.
I saw. Okay. I saw
Nightclubs,
some of the video you did with him.
And then Nightclubs also says Dever is Matt McCabe's cousin. Interesting there.
Who's Dever?
Charlie Lynn says reversible error
Dever?
number. Huh?
Who's Dever?
That was the female cop that we played in the.
Okay. Okay.
Charlie Lynn says reversible error number 593, not allowing Dr. Wolf to testify to flaws in not Wenchler's, he means Dr. Welchure's testing. She's not allowing defense. So what happened here, Solomon, is that on the cross-examination, not cross-examination, on the direct with Dr. Wolf, one of Dr. Wolf's one of his scopes of work was to review Dr. Welchure's PowerPoint and reconstruction. And therefore, when he was asked questions of, well, what do you have to say about Dr. Welchure's report? Or what did Dr. Welchure do? What did Dr. Welchure do wrong? Judge Cannoni did not allow that. She allowed him.
That's ridiculous. That's complete. Was it not included in his report?
No, it was reported. It was included in his report.
That is reversible error number 593. Well said, Charlie Lynn.
Well, there you go.
Ludicrous. I don't know if it's reversible error. It's definitely error. That is just, that's ridiculous. That's another asinine ruling.
Right. So all she allowed him to say is what he did, what his reconstruction showed, and his conclusions. But he was not able to say, I did this. Dr. Welchure did not do this. He was not able to say that.
That's unheard of. Unless it's some Massachusetts rule. Every case that I have in any state I've ever worked, where you have competing experts, Of course you're allowed to address the other experts' opinions.
Yeah.
Doctor, are you aware that this doctor is going to say this? Let me show you that doctor's report. Let me show you his conclusions. What's
Yeah, well, that's another thing. Okay. Mary Lochran. Brennan keeps changing the narrative. Taillight pieces, branches with Dr. Russell, and the ground with Dr. Wolf. Regarding Deborah, a lie if it's for the greater good. She's a disgrace.
Well, changing the theory of the case as the prosecutor definitely hurts. I'm not sure to what extent Hank Brennan did that. I didn't really follow all those examples, but I mean that's a real problem. When you're the prosecutor and you have to prove beyond a reasonable doubt what happened, and you keep changing the theory, it's a real problem.
Man Brown Jr. says he said no DNA on the arm.
Who
No
said
DNA. I'm not sure who he is. He said no DNA on the arm. Oh, well,
if that was the defense's experts, then it would come in on a rebuttal expert.
I don't think the arm was swabbed. I think that just the sweatshirt was swabbed.
Well, then maybe whoever left that comment can clarify.
Yeah. Nass says, was it a mistake for ARCA to not play sounds of the test? What do you think?
No, I mean I think the sounds are completely irrelevant. What do the sounds have to do with anything?
Yeah, I think it's I agree with you. All right, next question from Kelly. If Chloe bit, you must have quit. What does Solomon?
That's funny.
What does Solomon think of Barrows? Also, Dever did say FBI, and you didn't show him Bev's ruling on the dog DNA. LOL. Thank you. Yeah, I mean,
What does Solomon think of Barrows? Which one was Barrows? Remind me.
Okay, Barrows was. We didn't get to this, but Barrows is the Dighton cop. Very important witness, actually. So remember that you got Canton, you got Massachusetts State Police, and then you got Dighton, which is where Karen Reed's parents live.
I did see a portion of this testimony. He's the uniform who went to the Reeds. I remember his testimony. He took possession of, he was there when he saw the SUV and said that there was no damage, right?
Well, he said that there was it definitely did not look like
it was a crack, but it didn't look. Yeah, that was incredibly powerful testimony. Yeah. Very powerful testimony.
There you go.
And that's a great name, Kelly or Chloe, whatever.
Yeah.
That's a very funny name.
Mathis agrees. Brennan asked Dr. Wolf about high-profile clients like DOJ and Recovery. Clearly, that opened the door to hired by the FBI to a reasonable judge. So, Brennan, what happened here, this is actually very interesting. I didn't bring this up either, but I spoke about it in my recaps, that when Alan Jackson had Dr. Wolf on the stand, he asked him, what type of clients does ARCA have? And Dr. Wolf said, well, ARCA works for the NHL. They work for the Department of Defense.
Right.
And, just to show some of their more high-profile clients. Then what Brennan did, which was also a tremendous mistake. I think he was trying to score a point here, but it completely backfired. He asked Dr. Wolf, well, you have other clients too, like lawyers, insurance companies. They also hire you, don't they? And he said, sure. But then what happened is that Alan Jackson, before he redirected Dr. Wolf, he asked for a sidebar. And basically what happened is that because Brennan opened up the door to insurance companies, he was able to ask Dr. Wolf, you weren't hired by Karen Reed's insurance company, right? And he said, yeah, of course, we were not hired by them, because in the first trial, the reason why this is important, Solomon, in the first trial, there were some reports from the jurors, some of the jurors, that they thought that this independent agency which hired ARCA was Karen Reed's insurance company.
Of course, that's what they would think, which is why it's so improper and asinine for this judge to not let them say that they were hired by the FBI. That is insane that she's not allowing that.
Right.
But okay.
But once Brennan, right. So this comment is saying that once he opened up the door, they should be able to bring in the FBI, which you agree with.
I should have been able to bring it in from the beginning, but this definitely opens the door.
Right. And
Canoni probably didn't allow it, right?
Well, yeah, I mean, it wasn't brought up, but they already know what her ruling is going to be on that. And they've litigated already 100 times. But what was the significant part was that Brennan thought that this was going to be a good point to the jury that, oh, you also work for insurance companies. But then Jackson was able to state very clearly.
Hang on. Let me ask you something. This is really interesting. So Aperture was paid almost $400,000 by the prosecutor. Did anybody bring out whether anybody paid ARCA in the beginning?
So yes, actually, good point. So what happened with that is that it was brought out by Alan Jackson. This part he wasn't allowed to bring out, that he paid them for the first trial about $20,000, and then the defense.
But 1 second. Now the defense is not allowed to say. But at what point did we start paying you?
No, they weren't. No, they were able to say that. They were able to say very clearly that the other agency paid them to do the initial reconstruction, but the actual time testifying and travel expenses and everything like that, that the defense had.
The jury knows. I'm sure by now the jury has figured out that the other agency is some sort of oversight, whether it's internal affairs or FBI. I'm sure they figured that out by now. Juries are a lot smarter than we give them credit for. I'm sure they figured out that it's the FBI. And they know that the FBI hired these guys. That's awesome. That is just dynamite.
But coming back to your original question, so what did come out that ARCA was paid $20,000 by the first trial, and in the second trial, with all this dummy testing and other tail lights that they had to buy and install into the Lexus, it only cost the defense $50,000. And the Commonwealth has a contract with Aperture allowing for up to $400,000.
See, that does two things. Not only does that show the jury what the hell's going on, but if they don't get a conviction this time, the taxpayers will be up in arms over this. They will rebel against this DA for blowing through their tax money. This is not a massive city with a massive budget. If they spend $400,000 on experts, I would guess Brennan is at least $200,000 or $300,000.
Yeah, he's at least. I think he's
the rest of the case. I mean, they've got to be about $1 million in at this point, at least. And if they try her a third time, it's going to be an even longer trial, because now there's this entire trial's transcripts and experts to go through. Wow, that's crazy.
Here's a good question from Kristen from Manhattan. In opening statements, Alan Jackson presented arguments that weren't followed up on. For example, and this is one of the things actually I spoke about in one of my other videos about promising evidence that you're not going to produce. So, for example, stating there was a witness who would testify that John O'Keefe went into the house. How much do you think the jury will hold this against Karen Reed?
Is he going to present that witness?
No.
Why not?
Well, because I don't know if there is such a witness that.
Oh, that's very bad. That's really, really bad. Sometimes juries hate both sides and think both sides' lawyers are dirtbags. I don't think Alan Jackson is, but I think he kind of comes across as a very. He comes across as like a big time lawyer, and sometimes when you come across as a big time lawyer, it turns off jurors. And if they hate both sides, then that's great, because then they're not gonna award anybody with a verdict. I've had cases where juries have told me that they didn't like either side's presentation, didn't like the lawyers for either side, but that's a big strategic mistake to say that they're going to hear something that they don't hear. Now, the real question is, how much will they recall from the opening statement? Because this genius judge is not allowing them to write notes during the opening statements. Another one for brilliant decisions. So the question is, how much of that will they actually remember? I think that Alan Jackson's opening was exceptionally powerful. It told the jury so much more than the prosecutor told them, and it laid out a completely new version of events that I think the defense has been able to support.
It could be
with or without that witness not testifying.
Right. It could be that he was relying on a certain witness testifying that maybe they saw somebody else, not specifically John O'Keefe, but another individual in the house. There was some sort of recollection. I forgot who it was, Brian Higgins or somebody else there, said that maybe they did see somebody else come in, but not specifically John O'Keefe. And then the data he can argue because the phone recorded steps, ascending and descending flights of stairs and steps that were taken by his phone. So we can argue that's some evidence. But to say that there's an eyewitness, that may have been an overpromise.
Yeah,
Sharon,
it sounds like it.
Sharon Rees, if the diffuser was destroyed in Karen's headlight, how could it light up at all, cover or not?
I don't know. I have no idea. I don't know. I don't know anything about that.
Maybe that's something that on rebuttal they can explore. Nikki, I just got back from a birthday party and all the parents agree not guilty. We're only about 45 minutes away from Canton, so everyone here has been following the trial, looking forward to this week.
I'll tell you what's funny about that. I sent you a clip, actually, and I said, this is the defense in 45 seconds. It was an interview that somebody did of one of the neighbors, and the guy just completely summed up the defense in 45 seconds. It was so hit the nail on the head. I don't know what this DA is thinking. If he gets a conviction, I'd be shocked. But he's, I don't know.
Well, and here's coming back to the sound, and this is a good point. What difference does the sound make? They are claiming the collision happened right outside a house full of people.
Oh, well,
So-
I can tell you this. I know in movies it's loud. In real life, when a car hits a person, it's very quiet. And I can tell you that as in my capacity as an EMT. I've been at car crashes where witnesses are right there. They're 5, 10, 20 feet away, and they only know because they saw, didn't hear anything. In fact, what you sometimes hear is you hear brakes squealing, you hear people yelling, but the sound of a car hitting a person is really just not that loud.
All right. Debbie, on redirect, Kelly never mentioned the FBI by name. Okay, so yeah, people are saying that she did mention the FBI by name. Captain Rhett Snuggler gifted 10 Brother Council memberships. Appreciate that. Next question. Mani Vecchione. Why can't the previous Commonwealth theories come in?
Because it's not being presented in this case. So you can't, unless there's evidence or testimony of it in this case, you can't bring it up from a different case. Now, if the witness testified to it, like for example, if let's say one of the police witnesses for the prosecutor testified previously to a different theory, then on cross-examination, you can bring that up and say, well, now you're telling the jury this, but before you told the court this, then you'd be allowed to do that. But I don't know if that's what happened here.
Nicole K. Not sure if anyone answered this, but why are people saying some of the ARCA testing video was bad for the defense? I thought they showed her innocence. Well, first of all, I'll tell you that there's a lot of people out there that will try to bend every piece of testimony and evidence in their favor. So,
Right.
like,
which I think is silly. I think it's a big mistake to do that.
But I mean, I'm saying like there's people out there. There's people covering the case, other lawyers who are covering this case who are very anti-Karen Reed.
That's why they're anti-Karen Reed. Look, I obviously believe that she's innocent and that this case is a total joke, but that's not because I started off anti or pro Karen Reed. When you and I first started talking about this trial, I didn't know anything about it. I came in completely impartial. If there are people who are very pro her, people very against her, obviously they're going to feel the way that they feel.
Yeah, and I just to kind of give some sort of explanation to their position is that while you see that the taillight did shatter in some way, and therefore it could have shattered similarly with Karen Reed's Lexus, even though it wasn't exactly the same as Dr. Wolf showed it, but you do see some shattering of the taillight, and therefore kind of just ignore the fact that it didn't create any holes in the sweatshirt, ignore the fact that the internal components, the internal diffuser was not broken at the same degree, and ignore that Dr. Welchure most likely is going to testify that if that happened, there would be a lot more bruises, contusions, fractures, ligaments, tendons, injuries that we did not see on John O'Keefe. So
For sure.
they're
By
just,
the way,
they're
there's
just,
going to be an
they're
expert
just
that
keying
talks
in.
about that.
They're
That talks
keying
about the injuries. Oh, go ahead.
They're just keying in on one element of this test, which can be favorable for them, and ignoring everything else. But yeah, go ahead, Solomon.
No, the question is there going to be an ER doctor, or some sort of physiatrist or PMNR doctor or orthopedic specialist who's going to testify about what would happen to an arm at various speeds? How many bones would shatter? How many ligaments and tendons would rupture? Anything like that?
So we heard already from Dr. Russell. You're asking from the defense or for the Commonwealth?
Both.
Right. So the defense, we heard from Dr. Russell saying that you would expect a lot more contusions. And
okay, yeah.
And then there's also, we're going to hear from, again, Dr. Welchure, who's a biomechanical engineer who specializes in how the body reacts to certain forces and what injuries you expect to see. And he's also going to testify about the lack of any sort of serious injury to his arm. So we're going to hear about that. But I don't believe that the Commonwealth has anybody who's testified about that at all. Root Beer Float, member for 1 month. Counsel Daddies, you are much appreciated. Here we go from Mo. I beg to differ. I heard a person being hit by a vehicle outside my apartment, and I heard it with the door closed. 35-mile-per-hour impact.
35 miles an hour is going to be different. It also will depend on what part of the person hit. But at 20 miles an hour in reverse, the way that it was, I would not expect that to be particularly loud, especially if it hits his arm. I wouldn't expect such a collision to be very loud.
The Great 99. Who is worse? Who is a worse person, Marchand or Judge Bev? McDavid is a beast.
I never liked Marchand.
Yes, I can tell. Well, look who we have here. We have the DUI guy himself, Attorney Larry Foreman, who, by the way, in case you missed it, was in court when he got to see all the action with Dr. Wolf.
Make him a panelist. I'd love to talk to him. I've seen some of his videos. Been watching his videos off and on for years. Thank you for being here, Larry. You are dynamite in the courtroom. A lot of fun to watch. I've seen you shred multiple lying witnesses. Sometimes people who carry badges, unfortunately.
Well, look at that. Coming from somebody who does that himself, that's a pretty good compliment. So, Larry Furman, glad that you're here with us. And we have to get together, I guess, on a panel. Maybe me, you, and Solomon. Maybe we'll add Mark Bedrow to that. I think that would be dynamite. We'll have to do that.
By the way, you are right. Jackson's closing is going to be absolute fire. It's going to be, I call this ground and pound because I like the UFC, but this is going to be the kind of thing. His closing is going to be absolute ground and pound. He's going to bring up a point from the prosecutor and then destroy it. Bring up another point for the prosecutor and destroy it. It's going to be a lot of fun to watch. I'm going to watch that no matter what, no matter what's going on. I have to step out of a deposition. I'm going to watch that.
Just play it for the whole deposition there. Just say, we're going to take a little pause and watch this. I'm sure everyone will be happy with that.
Yeah.
Okay. Well, Larry, thanks for joining us today. We're going to have to get together. Send me an email. Here we go from Captain Rhett Snuggler. Bro Counsel, just wanted to thank you and King Solomon for your wonderful contributions to this channel. I rely on your objectivity and always appreciate the king, meaning you, Solomon, sides with me.
I appreciate the compliment, but King Solomon is my father.
Mandades. Deborah, what point was false? Time or date or people? What part was false? Time, date, or people?
Oh, yeah. That would be a fun point of cross-examination. Right, because she said it was a false memory. So what's false about it? Tell us where this memory came from. You told an agency that you could end up being charged with perjury over, that you explicitly remembered this happening the way that it happened, and that it was a wildly lengthy period of time or whatever the direct quote was. And that was just a completely concocted memory. Who concocted that memory for you? Interesting.
It's pretty interesting. Kristen from Manhattan again. In closing arguments, Karen Reed goes first while the Commonwealth goes last. How do you take advantage of going first and put the Commonwealth on the defense and have to respond? Would you talk about Hank Brennan? Would you talk about Hank Brennan as a prosecutor?
No, that can't be right. I've never seen any court system that works like that. The prosecutor goes first, then the defense goes, then the prosecutor goes again. So I don't think this is correct, Kristen from Manhattan. If this is correct, this is a uniquely Massachusetts rule, which I've never seen, and I'd frankly be very surprised if this is correct.
Well,
but the CW,
would you be surprised knowing everything that you've learned so far?
I would be, because this would not be a Canoni thing. This would be the way the court system works there, and I'd be very surprised if in Massachusetts there's no rebuttal argument and the defense goes first. I've never seen that. I've never heard of that. It'd be an interesting thing if it is. To answer the question, how do you take advantage of going first, putting the Commonwealth under the defense? So I'll tell you what I do sometimes, as defense or as prosecutor, because either way, no matter what, when you make a closing argument, the other side's going to go after you. If you're the prosecutor or the plaintiff, then you're going to make your closing argument, and then the defense is going to go, and then you're going to go again. If you're the defense attorney, the prosecutor is going to go, then you're going to go, then the prosecutor is going to go again. So what I like to do is I like to make a few of my strongest points while I'm making my argument, and then right before I sit down, I say, let me just recap a few very important points that I really wish Mr. So-and-so would address when he gets up and talks to you again in a couple of minutes. Point number one, maybe Mr. Brennan can explain to you this. Maybe Mr. Brennan can explain to you this other thing. And just kind of put him under pressure like that. And then that does two things. Number one, it makes the jury say, oh, yeah, Mr. Brennan, we'd really like to hear what you have to say about that. And number two, it forces whoever's about to get up and make the rebuttal to kind of rethink a bunch of stuff. Because now it's like, do you address those things or not? Kind of throws them off their game.
Yeah, I know you like to do that. But yeah,
I do that a lot.
Sharon Reeves, did anyone else think that Judge Bev looked a little too admiringly when Dan Wolf took the stand?
I think that when I see things like this, and I've seen a few comments like this about she's looking at this lawyer, she's looking at this witness. I think you're reading into it too much.
Nicole Kelly, I'm nervous when they say another agency, they might think it's Nick Barrow's department, the Dighton police, and different agencies are fighting. Maybe they think that there's not the FBI that's involved.
Okay, so even if they think that, it's fine. It shows that there's so many problems with this investigation that another law enforcement agency is conducting some sort of oversight and interviewing witnesses. And Jen is forgetting who she spoke to 4 minutes ago. And then this other woman cop who we just saw is changing her story. I don't think they're going to think that. I think they'll figure out that it's the FBI.
Sweet Lorraine, missing witnesses are Brian Albert, Brian Higgins, Michael Proctor. In the first trial, Brian Higgins said he saw a tall man enter the house. That's what I'm talking about. Could have been John O'Keefe, which AJ stated in opening. Yeah, that's what I was referring to. It could be that what Alan Jackson was assuming is that Brian Higgins was going to take the stand and then say that he saw a tall man enter the house and, be able to argue to the jury that's who they meant as John O'Keefe. But yeah, like I said, it was a bold statement, and I don't think it was necessary, and may have caused more problems than it helped, because you've got the data you can argue, and enough other arguments to argue that you needed to say that.
Mm-hmm.
Barbara Sturback, I still did not see it happening at all. No matter how drunk John was, I highly doubt he would stand there with his arm outstretched and get hit. It makes no sense. He's a trained police officer. Why would he just stand there? While
Can I ask you something? And I haven't really followed it enough to know this. Why couldn't it be that he was standing there and got hit like this? Why did it have to be that his arm was sticking out? Why can't it be that his arm was like against his side and he got hit like this into his body?
Well, I think that part of the problem with that is that he ended up 10 feet on the front lawn by the flagpole. If he got hit by the flagpole in that position, it would have hit him backwards. He would have ended up by the driveway in the street. And also, there'd obviously be a lot more injuries to his body.
Yeah, Barbara, it's a good point. It's inconceivable that anybody will conclude that he was hit by a car and that's how he got injured. It just makes no sense.
Shelley, thank you very much for that. We got Nicole Kelly again. They need to re-highlight Karen Reed time connected to Wi-Fi. I don't even remember it mentioned, meaning that she was connected to his Wi-Fi at 36, and they're claiming the accident happened at 12:32, which would give 4 minutes, which according to Google Maps, the estimated time of distance to travel is about 6 to 7 minutes. And something else, which I mentioned in the opening statement, is that Brennan messed up the timeline. He just completely messed up the timeline. And in this case, that's one thing that you can't mess up. If you're going to mess up anything, you can't mess up the timeline in this case, because in this timeline, literally seconds matter and definitely minutes. And he says at 12:23 was 7 minutes before the collision. And then he got to the flagpole at 12:34. Like, he was a little bit all over the place. And I understand, there's a lot going on, but if there's one thing that you're going to mess up, it can't be the timeline. That's what I think.
Right. And of course the car's coming, racing at him, and he's just standing there letting it come.
Which was like the last point. Yeah. Karen Bawden, last trial defense went first. Oh, so your last trial the defense did go first, Solomon.
Wow.
Then prosecution, 1 hour each. That was it.
Criminal case.
Please explain the missing witnesses, prosecution not calling certain witnesses. So again, I don't know what type of motion was filed regarding the missing witnesses. So I'm sorry. I'm a little bit ignorant about this specific motion. We know that there are certain witnesses that were not called. I don't know what the motion was based on and what the relief requested was. So I can't really opine about that. Well, anyway, it looks like that's the extent of the questions. And we're going to have to let Solomon go now anyway. It's about 1 hour and 30. He's got to take a shower after that game. Get ready for the hockey game you're probably going to be playing later. But Solomon, again, thank you so much.
Stay healthy and active.
Well, anyway, Solomon, thank you so much again for coming on to the show and giving everybody your thoughts. Again, we probably have about another week left to trial. People are expecting closing arguments next week already. So we'll see if that actually happens. We'll see if that happens. And of course, we're going to have to break that all down. But maybe next time we'll get with you and Larry Foreman, the DUI guy.
That'd be a lot of fun.
Okay, sounds like a plan. Let's do it, Larry. But anyway, Solomon, thank you so much. I'm going to take you off if you just want to say goodbye one more time, and then.
All right, have a good one, everybody. Good to be here again.
All right, well, there it was. There you go. That's Solomon, Brother Counsel. Always a great conversation with him. Very blunt. He's getting more fed up with this case as it goes on, as I keep telling him more details and more witnesses and different things going on. So it's always good to get his perspective, but he's kind of getting tired of this case, as you can probably tell as the conversations continue to go on and on. One more comment from Nikki. Karen is being sued in civil court for John's death. Can the family use Aperture in their case or any other expert witness hired by the Commonwealth? Of course. They could if they choose, and it'll probably be a lot cheaper for them because they already ran through the reconstruction. So they could use, in the civil case, all the same experts. And quite frankly, if I was defending Karen Reed in the civil case, I would also call these same ARCA experts, and now you don't have to pay for the reconstruction because they already did it. So it'd be a lot cheaper for Karen Reed, at least defending this case. So yeah, absolutely, they can use the same experts if they want, but it may not be, the greatest idea. But we'll see what happens with the civil case, because that's going to continue. It's on a little bit of a stay now, and we'll see once there's a verdict, we'll see what happens with the civil case. All right, well, everybody, thank you so much for joining us today on this Sunday. It was a great conversation, as we always have. Tomorrow, we will be right back here starting bright and early, 9 a.m. for the continued live stream. What are we up to? Day 29 now in the Karen Reed case. And we'll have a continuation of Dr. Wolf. And then, most likely, we'll get to Dr. Rensselaer, which I thought also Dr. Rensselaer was just great on the stand. These guys are just so polished. It's very, very hard to score any sort of points with them on cross-examination. They're just wonderful. They're just great. So we'll probably hear from him. But they'll also hear from Dr. Lapasorda or something, the neurosurgeon or some other neurologist who's going to testify on behalf of the defense. And then maybe they'll wrap their case up, and that'll be it. So we'll see you all back right here, 9 a.m. tomorrow morning for the live stream. Thank you all for joining us. Thank you, Solomon, and enjoy the rest of your Sunday.